report. Snowmageddon did not wipe us out. I'm still accustomed to having a living, breathing court reporter or stenographer at these things. So I'm going to try to keep up to the practice of having folks identify themselves on the record so that the recording and the people who transcribe the recordings afterwards have some idea of who's talking when and where. And if I forget, kick me under the table or something. So I'll call this meeting to session and ask everyone, starting with myself, to identify themselves for the record and for the benefit of the recorder. I am Fidel Del Valle, Chairman of the Board.
Russell Picuni's representing the DEP.
Taylor President, Fire Department.
Thomas Stettner, citizen member.
Elizabeth Maurer, citizen member.
Emily Lally, citizen member.
Madeline Lagori, sanitation member.
Jorge Martinez, Department of Health.
Dan Albano, Police Department.
And sitting with me is counsel.
Elaine Balsom, Deputy General Counsel.
Jim Maycroft, Council.
Is there a motion to adopt the minutes of the December 18 meeting? Don't rush.
There we go.
I believe everyone raised their hands, so I think it's unanimous. I'm going to have a presentation by the Deputy Commissioner of Oath and Director of the Board, Amy Slipka.
Good morning, everyone. Let's see if I can get this. All right. Most of you know what this is. It's a quarterly presentation. For those of you who are new to this, basically, the number of it sets forth the number of violations received by ECB, broken down by issuing agencies. There was a quarterly comparison of violations received, violations heard, and decisions rendered. I'll look at the elapsed time from hearing to decision date, and look at the decision results from each of the issuing agencies. And lastly, I'll look at the most commonly issued violations by agency. Okay, so let's begin. Okay, so violations received by ECB in the fourth quarter. From the Department of Sanitation, you can see comparing the third quarter to the fourth quarter, there was a decrease of 7%. From DOB, Department of Buildings, a 19% decrease, third to fourth quarter. Department of Transportation, a 2% increase. FDNY, 36% decrease. DEP, a 29% decrease. Department of Health and Mental Hygiene, an 18% decrease. Department of Parks and Recreation, a 47% decrease. NYPD, an 18% decrease. DeWitt, a 12% decrease. BIC, 77% decrease. And Landmarks, an 11% decrease. So overall, there seems to be a decrease. Now, if we compare the fourth quarter in 2013 versus the fourth quarter in 2014, a lot of the times we're going to see an increase. Remember, the fourth quarter of 2013, at this point, there were much more snowstorms, so it prevented somewhat of an issue. So in DSNY, you have a 15% increase between fourth quarter 2013 and fourth quarter 2015. DOB had a 20% increase, FDNY has a 2% decrease, Department of Transportation a 32% increase, Department of Health and Mental Hygiene a 12% increase, and YPD there's been a 33% decrease, DEP 4% decrease, Department of Parks and Recreation a 31% decrease. DeWitt, there's been an 89% increase actually. Landmarks, there's been a 320% increase from 10 to 42. And BIC, there's been a decrease from 12 to 7, it's about 42%. And that's where we stand there.
And that missing agency code is
The missing agency code, as you can see, it's decreased, so apparently we'll be in the agency codes, which is good for us.
we couldn't tell who the employee, which agency the employee worked for by their tax number?
And we couldn't tell that, no. You know, the way we know the agency and the way it picks up is the agency is, you know, the NYPD, you know, and such traffic or whatever, so.
Not only one system tax.
Oh,
Right.
okay, I thought,
That was Lieutenant Albano from.
I'm sorry.
It's okay.
So violations heard comparing the fourth quarter 2013 to the fourth quarter 2014. So for DSNY, violations heard is increased. For DOB, it's decreased 7%. FDNY, it's decreased 14%. Health and mental hygiene decreased 3%. DEP, it's increased 4%. NYPD, it's decreased 22%. DOT, it's down 12%. Department of Parks and Recreation, also down 29%. DeWitt is down 27%. Landmarks, we're getting a good showing, it's up 58%. Vic is down 38%.
Excuse me, this is Tom Spetner. Just to pick up on Lieutenant Albano's question, once we hear a violation, don't we know who the agency is? I mean,
We don't enter the agency, that comes in the sense that this information comes into our AIMS system. It's picked up that way. We can put in information, the judge can put information, there's nothing that captures the agency code at the hearing. So you can't put in who the issuing agency is at that point, it just won't be picked up. So even though we'll know at the hearing, it won't be picked up for AIMS purposes for it to be determined.
Actually, this is Fidel Del Valle. Actually, certain agencies can write summonses across a lot of these categories. Like the police department can write on any single one of these if they so choose.
oh, okay.
And as Elaine said, Elaine Boston said, some don't have tax registry codes and things like that, so it's just not picked up. It's a small percentage of the violations in total.
No question.
but Amy, that was the Dan Albano from the police department. In a way, that was like, couldn't somebody, an individual, look at these things and figure it out? Was that?
At this point in time, we just don't have the staff to do that. However, if you want to fund it, no, okay. Okay, decisions rendered. So we have a 5% increase for DSNY, DOB a 4% decrease, FDNY 5% decrease, Department of Health and Mental Hygiene a 6% decrease, NYPD, am I right? NYPD a 12% decrease, DEP an 8% increase, DOT a 12% decrease, Department of Parks and Recreation 15% increase, DeWitt basically 0%. Landmarks 280%, and Vic is a 67% decrease. So here's the decisions. You can see that most of our decisions are being heard, and the decisions are rendered within 82% less than 10 days, and 11 to 20, we're pretty much 98% decisions. Okay, so decisions rendered after hearings, you can see that in general, the total dismissed is 42%, in violation is 53%. That was the fourth quarter 2013. So for the fourth quarter 2014, it's 39.9% is dismissal and 59.5% in violations. It's about the same ratio. So the Department of Sanitation, 58% dismissed, 42% in violation. Fire Department, 91% in violation, 8% dismissed. Department of Buildings, 79% in violation, 21% dismissed. Department of Environmental Protection, 77% in violation, 13% dismissed. Department of Transportation, 62% in violation, 38% dismissed. NYPD, 49% dismissal, 51% in violation. Department of Health and Mental Hygiene, 56% in violation, 44% dismissed. Department of Parks, 58% in violation, 42% dismissed. Department of Information and Technology, 49% in violation, 51%. BET is 100% in violation, and Landmarks, it looks like it's 100% in violation.
course, they only have 4 cases.
Yeah. They were well written, I guess, and they proved that case. So the most commonly issued violations by agency pretty much hasn't changed. For a dog, it's failure to public transportation, failure to permanently restore your cut within the required time, failure to comply with terms and conditions of without permits, and opening streets without permits. For NYPD, it's the vending in the bus stop or next to a hospital or crosswalk, failure to display your license and or plate, and items not in or under the car. DOB, it's unlawful acts, failure to comply with the commissioner's order, failure to comply or to file a certificate of correction with DOB, and failure to maintain the building in a code compliant manner. DSNY, here, dirty sidewalk, dirty area, failure to clean 18 inches into the street. Okay, Department of Environmental Protection, failure to submit an annual backflow, operating without renewing your expired certificate, and failure to install a backflow preventer. Fire Department, inspection and testing, fire protection system failed to prevent unnecessary unwanted alarms, and posting of permits and records. As Department of Health and Mental Hygiene, failure to eliminate rodent infestation, shown by active rodent signs, failure to eliminate conditions conducive to rodent debris, vegetation, and failure to eliminate conditions conducive to pests. So, landmarks work without a permit, miscellaneous violations work without putting up a banner or awning without proper permit or approval, and again, it's basically the same thing, no proper approval for any alteration to your facade. Do it, failure to provide working public pay telephones, failure to clean and maintain the public pay phones, and installing, operating, maintaining public pay phone without a permit. Department of Parks and Recreation, failure to comply with directions, failure to comply with bicycle riding restrictions, and I almost got knocked over by someone riding on the sidewalk yesterday, so unleashed or uncontrolled animals in the park.
How would you like the license plate?
No, I didn't, but I was thinking about it. I was like, it was one of the restaurant people. I'm like, oh, let me see if I can see his name. BIC, it's failure to register wholesale and or market business, idling of motor vehicle, and failure to register wholesale and or market business as per the subsection. So, and appeals, number of appeals for fourth quarter, you can see it right there. Department of Sanitation, 329, DOB 235, Fire Department 91, Health 63, DOT 38, DP 36, Parks 24, and PD 17, and Village 10. And faults, again, BSNY 71% fault rate, DOT 8%, and Health and Mental Pension 6%. And that's it. Any questions?
You mentioned before, the Dan Albano, you didn't have the full for PJ?
Those are the three, that's the three highest at this point, so you must be getting a good shot, I guess.
Just as a matter of information, this is Fidel Del Valle. Every city employee has a tax ID, except, generally speaking, only members of the police department know what it is. And I think the tax ID number for most people is actually their pension number, but I'm not sure. That's something I researched a long time ago. And it became custom and practice to put your tax ID number on a summons, because if it started with the police department, because if you put your shield number down, shield number changes as you're promoted and like that, and the only thing that's consistent is your pension number, your tax ID number. Now we have 27 different numbers on your paycheck that identify you. Maybe that's something that we might try to get some kind of consistency to identify who writes the summons by using their city ID number or something like that. Might be helpful. We have a proposal by the sanitation department.
Madeline LaGuardia, Associate
Council of the Department of Sanitation. The first proposal we have before the board today has to do with electronic waste. New York State law bans the Department of Sanitation from picking up electronic waste in our solid waste stream. As a result, we are in the midst of promulgating rules, which we should publish as final sometime this week, that would make it unlawful for any person or commercial establishment to place any electronic waste out on the curb for collection, either by the department or by a private car.
Stand by for technical difficulties.
Or by a private cargo. The fine would be $100. Right now, the department is in the midst of an educational campaign to educate residents and businesses that e-waste cannot be placed out on the curb for any type of collection by the department or a private carter. There are several options for persons to have their e-waste collected, including the department's e-cycle program, which is open to any building that has 10 or more units. Our website lists many entities that take back electronic waste, such as Best Buy and Staples. And the Lower East Side Ecology runs events, as well as the department runs special events for e-waste take back. The penalty associated with this would be $100. Right now, the department is putting this sticker on all electronic waste that is out for collection. It says, as of January 1st, 2015, it is against the law to put electronic waste out for DSNY collection. Please call 311 or visit nyc.gov/electronics for options to safely dispose of electronic waste. Any questions?
Jorge Martinez, DOH. In section 1-04.2, where you define electronic waste, you limit computer peripherals to items weighing less than 100 pounds. Why is that?
Our definition here is the state law.
So if you have a fax machine that weighs 200 pounds, you consider waste, electronic waste?
Facsimile machines are in there.
No,
They're
but only those are
listed.
limited to weighing less than 100 pounds. So if you have one that weighs more,
Well, because usually if you have a printer that weighs more, you have to deal with a company to come and get it. Manufacturers are responsible for taking back all electronic waste.
But what if you don't? What if you have a 150-pound old Hewlett-Packard printer and you put it out to the curb? I mean, I can't see the sanitation guys putting it on a scale and weighing it.
Well, something like that probably would be placed out by residents. It would probably be more of a commercial establishment to put that out. Under state law, manufacturers are required to have take-back programs throughout the state. And that would fall under the take-back programs pursuant to the state law.
what would sanitation pick up an item?
No, we will not be picking up electronic waste from the curb,
Regardless of how much it weighs.
regardless of how much it weighs. If it's out there, if it's TV, it's a little, we're not picking it up.
Elizabeth Mauer, citizen member, but I think the question is if somebody puts out something that's heavier than 100 pounds, they would not be subject to this violation. Is that correct? Is there a separate, is there a separate?
This mirrors the state law. This mirrors the state law. I was not the attorney for the department that drafted this rule. So this mirrors the state law. And the rule's not really up for discussion, it's more the penalty associated with the rule. Our comment period closed last week on the e-waste rules.
Well, we all know what's coming then.
Any other questions? Is there a motion to approve the proposed penalty? I think that's everyone. Any abstentions or nays? Sanitation Department abstained. The schedule is approved. And of course, the staff is directed to proceed with the publication per kappa. We have another presentation on collection bins.
Our second presentation has to do with publicly accessible collection bins. I'm sure everybody has seen these wonderful bins in your neighborhood. all around on public property and some on private property. This law basically expands the existing law on publicly accessible collection bins. Back in 2007, the city prohibited bins from being placed on public property, but allowed bins to be placed on private property. The law still has that aspect within it. However, under the previous law, the Department of Sanitation had to tag a bin and collect it, and we were allowed to remove it within 30 days after the tag was placed. What we were seeing happening was on the 29th day, these entities would go in, take the bin, and move it to another location, thus starting the clock all over again. Last year, we tagged over 2,100 bins that were placed on public property. Since the law was not signed by the mayor, but since the law became effective, since the law was lapsed into law back in December, we've only tagged 48 bins. That is amazing, because people are already ready that this law is going into effect as of March 13th. So what we are requesting are several penalties associated with certain violations as outlined by Local Law 67 of 2014. And there is the requirement that any bin on private property be maintained in a neat, clean condition. A requirement that all private property, all bins on private property be registered with the department, and that they also have annual reporting requirements to the department that we will count within our tonnage requirements for recycling. As most of these bins are recycling, obviously most of these bins are textile bins, but there are several other types of bins that could pop up out there, such as e-waste or other types of bins that we're sort of ready in case those pop up as well. There, an individual who does place a bin on public property is subject to a $250 fine, as well as all storage and removal fees associated with the removal of the bin. And if they decide to affix the bin in any matter to city property, either affixing it to the sidewalk or fencing, they would be subject to a $500 fine, in addition to all storage and removal fees. All fines are fixed in Local Law 67. DSMR had absolutely no discretion coming here with this penalty schedule.
Emily Lally, citizen member. Does the time frame on when you can remove them?
Oh, yes, I'm sorry. We can remove them immediately. I apologize. As of March 13th, we tag it, we can remove it.
Dan Albano, the police department, like the tags, is it a presumption that if your name appears on the bin, you place it there?
Yes, but most of these bins will not have any identifying information on them.
Just one citizen member. Are these bins limited to just commercial properties?
Public property. They are prohibited on public property. However, private property, private parking lots, they can have a written agreement with the bin owner, and it is lawful on private property. We're not prohibiting
Is there a
those.
size limitation on the
No.
bin?
No.
Because sometimes with residential properties, they have these bins on their property. Do they have to register those? Just for regular recycling?
Wait, that would, could you explain a little further? I'm sorry.
They may have bins on their private property for regular recycling. Are we
Wait,
talking-
that wouldn't pertain to
Those
them.
are not-
That's totally different.
Nah, I saw that. I just want to make sure.
Any other questions?
Sorry. I have a question from the fire department. I'm just wondering, when people register the bins, are there certain regulations regarding the registration, like how far it has to be?
No, it's on private property.
Only on private?
Only on private property.
So there-
Written agreement on private property.
Is there a motion? I think it's unanimous, except for Ms. Legori from sanitation, who is abstaining. The next item is from the Department of Buildings, but the representative is running late, so I'm going to move that to the tail end. See if he gets here on time. The presentation on proposed rules regarding amendment to sanitation penalty schedule.
board meeting. DSNY is asking ECB to amend section 16-471 of its sanitation penalty schedule so as to restore the intended purpose of the law to apply to owners of vehicles related to bulk collection of recyclable containers. Just to note, Law Department and the Mayor's Office of Operations have both certified this law. Any questions?
No questions? Is
Sorry,
there a
I have
mo-
one question.
Oh, sorry.
Could be wrong here, but my memory recalls we were changing, this used to be the $2,000 fine, is that correct? And this went down to $500 or what we call this all correctly?
This is not, I'm sorry, Madeline McGuire, sanitation. The fund that they're changing has to do with mobile redemption, not theft of recycling, so there's different funds. Thank you.
Anything else? Is there a motion? It's unanimous, except for sanitation again, which is abstaining. And it is approved, and it will be published for CAPA regulations.
Okay, our next rule is a final rule. Again, Diana Haynes, Assistant General Counsel. This is a final rule first presented by the Department of Buildings. ECB is making amendments to the DOB penalty schedule in order to enforce the 2014 construction code update. Note that this final rule has been published on the city record and public hearing is held. No comments or testimony from the public to receive. Are there any questions on that?
If there are no questions, is there a motion? And it's unanimous for everyone present, and it's adopted, and we'll proceed with a final publication. We have a DOT penalty schedule?
Yes. Our next final rule was first presented by the Department of Transportation regarding failure to obtain confirmation numbers prior to street openings. ECB is amending the DOT penalty schedule to decrease the penalty for failure to obtain a confirmation number prior to the expiration of the street opening permit from $750 to $250, and is adding a new provision to the schedule to impose a $750 penalty for failure to obtain a confirmation number 2 hours prior to commencing the backfill. Once again, this final was published in the city record, and a public hearing was held, and again, no comments or testimony. Oh, you did have a comment. There was one comment.
There was a comment received by National Grid, from Brooklyn National Grid, rather. Are there any questions or discussion? Is there a motion? It is unanimous by everyone present. They are adopted and they will be published. I believe we actually have another one.
Yes, this is another final rule. This final rule was first presented by the NYPD regarding failure to yield and leaving the scene of an accident, both part of the Mayor's Vision Zero action plan. ECB is amending the DOT penalty schedule in order to enforce these two different provisions. The final rule has been published in the city record and a public hearing was held. Are there any questions?
Jim Baker, Council to the Board. The proposed bill was published in the city record. The final will be published sometime next week.
What will be published next week would be the final rule proposal or the final rule as enacted?
The actual final will be published in the city record after 30 days elapses, and will be coming back to you.
Okay. Is there a motion or are there any questions first or discussion?
I'm going to have to abstain.
Okay. Is there a motion? It is approved by everyone, and Daniel Albano is abstaining. And,
I was against.
oh, I'm sorry. And Emily Lally is voting against, I'm sorry, for the record. It is approved and it'll be published. I believe we have a DEP request.
Good morning. Russell Kukunis, Assistant Counsel with the Department of Environmental Protection. This month, A&P has actually 4 different types of cease and desist requests, which I think might be a record. The first one that I will address will be the one that was sent out yesterday, for which I apologize. The sewer cease and desist requests, which are very rare, do not come through DEP Legal, so I didn't realize that they had only sent it to Judge Lazarson and not for inclusion in the board package, so that's why you only got it yesterday. This is for M-Star Pizza, which is a restaurant located at 11702 Atlantic Avenue in Queens. The location, pretty much all through last year, was served with a series of commissioner's orders and notices of violation, requiring them to provide access to their existing grease trap and to install an additional grease trap. And they have disregarded all of those commissioner's orders and notices of violation, defaulting with regard to the violations in July, August, twice in October, and in December. So based on the continuing failure of this establishment to comply with the grease requirements as set forth in the commissioner's orders that have been issued to them, DEP is requesting that the board issue an order to cease and desist.
Any questions? Excuse me. Is there a motion? The request is unanimously approved. I assume Mr. Kukunis will abstain.
Yes. Okay, the next group, there are 11 requests for cease and desist orders relating to boilers that have not renewed their certificates of operation to use a fuel other than number 6 fuel oil. There are 3 points that I'd like to make about these 11 requests. 81 Realty Company at 311 East 72nd Street has 2 of the 11 requests, and that is because they have 2 different boiler burners in the same building, both of which have expired certificates to use number 6. So there are 2 separate requests for that location. On the request for Park Terrace Realty LLC, there is a typo on the cover memo. The premises should be 229 Seaman Avenue in Manhattan instead of 223. The affidavit and the notice of violation that were issued had the correct address of 229. So on that one, just amend the premises address on the cover memo to 229 instead of 223. And the request for Parcel 1 Company at 35 East 84th Street is a resubmittal of a request that had been approved at the December meeting. The order had gone out with a typo in the premises address. It said 315 East 84th Street instead of 35. So presumably that's why no one appeared for the hearing. So we're bringing that one back as a new request with the correct address. So there are a total of 11 of these.
Any questions? Discussion? Motion? It's unanimously approved, I believe, with one abstention.
One abstention, correct. Okay, the next group we have 18 requests for cease and desist orders for failing to install backflow prevention devices. All of these are the usual situation where the building owner has been ordered to install the device. After their failure to comply, they've been issued a notice of violation, which has been adjudicated in violation, and they are still not in compliance with the requirement. So for each of these 18, the department is requesting that the board issue an order to cease and desist.
Any questions? Motion? It's unanimously approved. With one abstention.
One abstention. And finally, we have 4 requests for cease and desist orders under the noise control code. I'll go through these quickly one at a time. The first one is for the United Talmudical Seminary at 6620 Thornton Place in Queens. This establishment apparently has a commissary or cafeteria, and the kitchen exhaust has been cited for being too noisy on 3 occasions starting in June of last year. Due to the repeated violations and continuing failure to come into compliance, DEP is asking the board to issue a cease and desist order. The next one, the respondent is Bake Ridge Bagels at 9417 3rd Avenue in Brooklyn. This one again is for a noisy kitchen exhaust. They have been cited on 6 occasions going back to the summer of 2013 actually, and due to their continuing failure to bring the kitchen exhaust into compliance with the noise code, DEP is asking the board to issue an order to cease and desist. The next one is for Mukambika Group at 194 Bleecker Street in Manhattan. This is an Indian restaurant, I believe, and their kitchen exhaust has been cited on 3 occasions going back to January of last year and most recently January of this year. So based on the continuing failure to bring the kitchen exhaust into compliance with the noise code, the department is requesting an order to cease and desist. And finally, we have LX Food Grocery at 9614 Corona Avenue in Queens. This one is for a refrigeration unit, and that unit has been cited 4 times for being too noisy, and due to the continuing failure to bring the unit into compliance with the noise code, DEP is requesting an order to cease and desist.
Any questions? Motion? It is approved with one abstention.
Abstention. All right, thank you.
And we have a public buildings proposal concerning penalty schedule.
Good morning, everyone. It's still January, so happy New Year. I apologize for the tardiness. Ronaldo, Department of Buildings. The Department of Buildings this morning request an amendment to ECB, DOB's ECB's counter schedule to more adequately enforce some changes that were brought about mainly by the enactment of Local Law 141, which is called the 2014 code, building code. In the 2014 building code, if you recall, a couple months ago, we did a massive a change to our penalty schedule. But however, we're coming to you this morning to bring some new charges to add to our penalty schedule that were brought about by this local law. In addition, we are also doing a little housekeeping in our penalty schedule by clarifying some description of charges and also changing some sections of law that are in our elevator charges for maintenance, just to more specifically bring it down to what we're trying to describe. So I don't know if everyone had a list of the charges that were included in your packages, but if you need it, I have it. They relate to the requirement to obtain service equipment certificate of compliance prior to operation for any service equipment. That charge was already inside our penalty schedule. However, it related only to elevators. We want to broaden it to any service equipment as described in the administrative code. Service equipment such as boilers, escalators, elevators, air conditioning equipment, etc. We tried to narrow the maintenance of elevator equipment by just changing the section of the law specifically to 30. It's right there. It's articulated in the changes here to instead of 301.1, which relates to maintenance of buildings, to just to 304.1, which talks about maintenance of elevator equipment. Also, we're adding some new charges related to testing of the elevators, requirement to test and inspect these elevators. The new code added a requirement to, clarify, I guess, the fact that you can't tamper with a vacate order once it's posted on a premises. It was kind of implied, but it wasn't quite there in the code that you cannot tamper or deface an elevator or a vacate order for that matter. And we've successfully prosecuted, but we just want to make sure that the new code clarified it, so we've added those sections. Also, failure to obey a vacate order. Believe it or not, quite a bit of people just kind of rip down the vacate order notice and go back and live in these illegal apartments. We never had a charge for that. The new code added that charge, and you'll see it on the penalty schedule. That's the most significant penalty that we're asking for today, $4,800. And interesting enough, the zoning resolution always require or made it illegal for anyone in a special natural area district, aka anywhere in Staten Island, to remove a tree or any natural feature. But we're just targeting trees without a permit from the citywide New York City Department of City Planning. And that summarizes it. The penalties are outlined in a spreadsheet, the changes, that is. If you have any questions.
I'm sorry. Go first.
Excuse me, Elizabeth Noor, citizen member. Could you explain how the default penalties were set, please?
Sure. At the bottom of my letter, it explains the penalties. Once we set a minimum penalty, which is the guideline penalty, as to what we impose if it's found in violation, default penalties are 5 times those penalties. And then you have what we call an aggravated factor for violations. An aggravated 1 factor. An aggravated 1 violation is any charge that occurred in the last 3 years at the same premises against the same respondent can be aggravated to 2.5 times that amount.
The reason I asked was that, at least for not one of the ones where the penalty is being newly proposed, but it's the class 3 for the failure to maintain the elevator.
Yeah.
The default penalty for that is, the penalties are the same across the board, so.
Right, because the administrative code sets the default penalty sets the penalty for class 3 a maximum of $500. So we can't go any higher than 500.
And then can I ask one more question? just in terms of their failure to obey a vacate order, that applies to a resident who is that there's a building subject to a vacate order,
Typically, yeah.
and the resident moves back in, so an individual resident could be fined
We don't cite residents.
as a matter of practice.
No, we don't. It's all against the owner. For these charges, at least. I mean,
But
illegal
the
conversions-
code would allow a resident to be cited, but.
Yeah, it does, it would, but, we've never, it needs to be folks can talk about, we've never cited residents, except in illegal hotels. That actually, the code actually allows us to do that. Because these charges relate to illegal conversions, we don't think the residents are to convert these properties. They are converted and then rented.
But if here, this is a new violation for failure to obey a vacate order, correct?
But the vacate order would have been issued to first. Remember, we have to issue first, right? So we vacate the premises. And yes, it would allow us to issue it to a resident if he disobeys the order, but typically we fail to vacate to the person who we issue the vacate order to, which would be the owner of the property. But it does, yeah, the code does allow it. I'm just saying, as a matter of practice, it wouldn't be too successful if issued to residents.
Dan Albano from the police department, but Ronaldo, we do find people that get complaints from DOB sometimes that there's residents in the building where there's vacate orders posted.
Right.
And what we had done in the past was, on some very rare occasions, is to arrest people for obstructing governmental administration if they refuse to move.
Right, but that's different though.
Right, now we have this civil penalty as an alternative or really
Right,
a first step.
I think the police department actions are a little enhanced enforcement. This allows us to bring a administrative charge against the owner of the property for failing to obey this vacate. He's responsible. Once we put a vacate order sticker on his premises and lock the doors, if it's open again, it's his responsibility to do that. I mean, a lot of owners will cry foul a lot of times and say, well, I didn't alter this property. Also, I didn't put it in a bathroom in my basement, but you're the owner of the property. The tenant is you can't prove that. So since the code says that you as owner is responsible to maintain your property, then that's who we go after.
I think what I'm hearing, Dan Albano from the police department now, is that what I'm hearing is that the police department should not use this as a tool of residents.
No, I'm not saying that. The police department acts a lot of times in conjunction with other agencies and go and do some enhanced enforcement. But the Department of Buildings inspectors would be able to use this administrative tool since we can't perform arrests, we can't do that. They can charge an owner if they fail to obey the owner. And again, the code allows anyone, but we just go after the owner. Same thing with a stop work order, for example. We would issue fail to obey the stop work order, which is a pretty high fine, the same fine as fail to obey.
I have a concern that because the code allows it, that this could be used to impose very high penalties on residents. So I'm just wondering if there is any way, and I don't know if there is legally, to have a separate penalty for failure to obey a vacate order for a tenant as opposed to the owner of the building.
That would be something we'd have to bring back and discuss with our commissioner, I guess. The code specifically just talks about not obeying a vacate order, anyone. So it is a serious matter regardless of whether it is the tenant doing it or the owner allowing it. In fact, you will find a lot of times where the owner may try to put his or her foot down and say you cannot come back in, you have a vacate order, yet the tenant may go around the owner or something, but at that point, we don't get involved or we cannot get involved in who's allowing the action. We have to go after the person who we think who we know to be responsible for maintenance of their property, and that is the owner. So I know I can't tell you that one will never be issued to a tenant, but it's not typical of the Department of Buildings Enforcement for illegal conversions, especially to go after a tenant. We've never done that as far as I know, and I've been in charge of the administrative enforcement unit for 8 years. It's just practice to go after the owner.
This is Fidel Del Valle. I know that in some instances where there are posted vacate orders, you find essentially squatters moving in, and that becomes a serious safety hazard issue, because there are fire considerations. Very often the premises doesn't have electricity or water or gas. In the winter, they'll try to heat the place with some other heating device, and it becomes a very dangerous situation.
And then there's maybe just one question. I mean, what's the process leading up to the vacate order? I mean, are you?
Oh, okay.
If there's
So,
a tenant living
actually,
there, do they
sure.
get 30 days to leave? If it's, how does that look?
Okay. Well, we don't always vacate illegal conversions, actually.
Okay.
And I'm speaking primarily illegal conversions because that's our primary use of vacate. Whereas commercials, it's harder to enforce the vacate. But first, we have to identify violations that against the property. Actually, code says that there must be some violations that are eminently hazardous or dangerous to the occupant. But when we move into vacate, we have to, with respect to users, typically we'll have to determine that there's not sufficient light, that their exposure to carbon monoxide or also with less than one, not less than, but one, not more than 2 egress from the apartment. And so we put those into consideration before we decide whether or not this illegal conversion has to be vacated. Sometimes illegal conversion is just cited to correct, but when the threshold, when it comes down to egress, lighting, and exposure to carbon monoxide, they usually vacate. So it raises to another level before we issue a vacate order. When the order is issued, that is it. Is it immediately issued? It's immediately issued, and so we don't extend the time to say, well, give them now 30 days or a week. We issue a vacate. However, they can request to go back in to remove their stuff under supervision.
I recognize the safety concerns, and I fully endorse having high penalties imposed on owners for failure to obey a vacate order. My concern is that individual residents of a building, if the owner lets them back in violation of a vacate order, they may not fully understand that what they're doing is violating a vacate order. They might believe that they're actually moving back in legally, that the owner has corrected the conditions. And I think you referred to the illegal hotel conversions and enforcement against individuals. I think we were presented with, we were given a presentation by the Special Enforcement Unit concerning that, and assured that the driving force there was not to enforce against individual apartment tenants, but I'm not sure that that is borne out in practice.
Owners.
Sorry?
Apartment owners, right?
Well, apartment, either tenants or owners who were renting out a place for less than 30 days.
Apartment owners.
I'm not.
Individual apartment owners. So the person who's renting, the tourist that's renting is not.
No, but but if you could still be a long-term tenant.
I see.
Anyway, so I would propose that the department consider adopting this penalty that would apply to building owners, but a lower penalty that could be imposed on individual building residents. I don't feel comfortable
How-
voting in
yeah.
favor of this rule as it's.
I hear you. How does that, though, affect, diminish the hazard? You know, if an owner, if an owner allows them or a tenant kind of
It
ignores
doesn't,
them?
it doesn't diminish the hazard one bit. It's just that I'm concerned about imposing very high penalties, especially the default penalty, which could be up to $24,000 on an individual person who may be re-entering an apartment under the illusion that they're doing so legally, which I don't think is an uncommon scenario.
It's not fair to use the default penalties because the default penalties are just typically, no one answers the ticket.
Right,
They
which
come in and.
which is probably more likely in the case of an individual tenant who may not.
Right, but then I wouldn't make excuses for a person not to answer a ticket. You know, take the penalty. But in essence though, I don't know how I can carve this out for tenant versus owner when the code just does not.
There's no way to do that.
I don't see how we can get that past the legal, I mean, as somebody who can probably explain.
Well, we can-
I mean, but there's nothing that says the owner versus the tenant, so there's no separate sections of law. We would have to maybe arbitrarily come in and say when tenants do, when a tenant do it, it's this penalty, when an owner does it, it's a different penalty. I think we'd need support from the administrative code on that.
So there's no way to just within the penalty schedule have.
No, because it would be arbitrary. I mean, I think, right, if you just say, if the code says you should not vacate, you should not disobey a vacate order. And then we say, well, when a tenant does it, it's one penalty, when an owner does it, it's a different
Well, I mean,
penalty.
different penalties for, class 1, class 2, class 3.
Oh, I see.
So,
I mean, making it a class 2 violation, if a tenant does it, I think that would be, that's also, because the definition of a class 1 is the actual facts.
That wasn't what I was suggesting. What I was just saying was that there are different penalties, but I don't know if that's because the administrative code defines class 1, class 2, class 3.
Yeah,
So it doesn't.
The classes would, because we're arguing here that's the per se class 1 to disobey a vacate order. Same, by the way, as a stop work order. And if a tenant disobeys a stop work order, they're going to be charged already $4,800. So a stop work order, this is already existing for a stop work order.
I personally see that as different.
I understand, but the seriousness of the thing is, if there is an order because there's something imminently dangerous about the situation, and you're told not to either stay out because by staying in you're putting yourself, as first responders, and everybody else at risk, and you continue to do that willingly, I think that is the gist of the whole thing, and the high penalties to prevent you from doing it, not to make it more affordable at some point, depending on who is doing it, because they will. An owner will come in and argue, "Oh, I didn't allow this to happen intentionally, just so he can get a lower penalty or qualify for a lower penalty." So I think we don't want to go down that road. I don't think. I mean, I can bring this back to the commissioner, but I don't think we want to go down that road and try to differentiate between owner who did this. But I understand your concern. It's high, but it is the precedent. We charge $4,800 for 3 different violations. Fail to vacate a stop work order. Fail to vacate and now we're proposing to vacate. Fail to obey a stop work order and operating a crane in an unsafe manner. Crane operations. Those are the 3 charges that we go this high on because of the hazard that we see, and it's strictly to deter those activities.
I think we can vote on this proposal and recommend that you take back to your commissioner our concerns and explore the possibility of having a separate schedule as pointed out by Ms. Snauer.
Dan Albano for the police department. Just want to set something straight for the record, Elizabeth, is that the police department doesn't arrest people based on the vacate orders. It's based upon, we don't do anything on our own initiative. The buildings department would have to come to us and say that they tried everything to get this person to comply with the vacate order. There's still a resident inside, and we'd like to get him out. And I've even turned that request down if the vacate order was issued, like sometimes it's a year ago. And now, for some reason, the buildings department wants to get them out now. Well, where's the imminent danger that we're going to make a forcible entry into someone's home? It has to be a dangerous condition, and they won't comply with the vacate order, and then we'll take steps. We don't do it on our own initiative.
Are there any other questions or further discussion? Is there a motion? Is there anybody voting negative? With 2 votes in the negative and 1 abstention, the motion passes. And it will be pub.
I will report back after discussion, see if there's anything in relation to this particular charge for failure to.
Thank you.
Thank you.
Oh, okay. We have a request for a sealing order by Kelly Corso. I'm sorry. Peter Schulman.
Good morning, Peter Schulman, Assistant Director of ECB. This month we have 26 total pre-sealing reports for the board. 3 of them pertain to the failure of boilers and burners at the premises to comply with the air code. In the first, the hearing officer recommended no further action is necessary because the respondent came into compliance. In the second 2 of those, the hearing officer recommended that the cease and desist proceedings be discontinued. In one of those, because the C&D mistakenly referred to the addressing as being in Queens when it actually was in the Bronx. In the second, because the respondent established that it sold the premises prior to issuance of the NOV. So those are the 3 boiler burner pre-sealing ones. I don't know if you want to vote on those first, and then we'll get to the other one.
Sure. Is there a motion? Are there any questions, first of all? Is there a motion? It's unanimous.
The remaining...
BP abstained, I'm sorry.
The remaining 23 pre-sealing reports pertain to the respondent's failure to install backflow prevention devices. 21 of those, the hearing officer recommended no further action because the respondent came into compliance by installing the required backflow prevention devices. In the last 2 of those, the hearing officer recommended no further action or that the C&D be discontinued because the premises, because upon further inspection by DEP, it was determined that the premises no longer required backflow prevention devices. So that's it for the last 23, and that's all of them.
That's all.
That's all of them.
Any discussion? Question? Is there a motion? And it is unanimous with the P abstaining. That's Mr. Kunis. Am I pronouncing that right? Am I pronouncing your name right? We will now move to executive session, and I'll ask non-staff, non-DEP, or the PCB personnel to kindly leave, and we'll reopen to the public in a few minutes. Is there a motion to accept the appeals recommendation? It's unanimous. Is there a motion to adjourn? We are adjourned, and I'd like to remind everybody who hasn't signed in to sign in, please. Thank you very much.
Reverse, silent, please.